Thank you very much, everybody, for being here, and welcome to UCL. Welcome to UCL, and a very warm welcome from IViR, the Institute of Brand and Innovation Law. We're very delighted to host you for our annual copyright lecture tonight here, Copyright Law and AI, time to revisit copyright registration, maybe. Now, we live in very interesting times, and life happens, things happen. So I have to introduce a little bit the evening before I pass it on to our wonderful chair, and of course introduce our wonderful chair. So we may have noticed that the lineup for tonight's panel looks slightly different to what we put up several weeks ago when we set up the event. And unfortunately, I have to inform you that last week and earlier this week, we were informed that 3 of our originally planned speakers will not be able to join the panel tonight. So I'm passing the apologies from Adriana Moscoso from KESAC, from Krishna Sood from Microsoft, and Jalise Mangum from the US Copyright Office. All of these people are unfortunately unable to speak tonight. However, we thought that having the debate and having a rigorous discussion and debate on this topic is important and necessary. And we will go ahead. We are going ahead. And a word on the topic from me first. So traceability of AI works is and has always been a vibrant and necessary topic to have. Whether we label it as registries, maybe that's an offensive word in the context of copyright law or not, or good record keeping of works, one way or another, knowing who the author, right holder of a work is important for various reasons that our panel will unpack tonight. And in the fast developing times that we live in terms of generative AI, it's even more pertinent to be able to keep track of these works. So that is the theme for tonight. And I have the wonderful pleasure of introducing you our chair, Amanda Harcourt. She is one of our UCL's honorary professors of practice, but Amanda is a force of nature, and you will see this yourselves. So we are in very good hands tonight. She has a huge and long career of advocating a lot and strongly and passionately for the interests and rights and revenues of authors and performers in various jurisdictions. So, without further ado from me, I pass the floor to you, Amanda, and thank you so much for being here and doing this with us.
For not cancelling. Yes. Thanks, Elena. Oh. Well, welcome everybody. We're very lucky to have 2 pretty stellar speakers here tonight. James Bennett from the Copyright Licensing Agency is head of rights and licensing there, and he's responsible for maintaining and developing CLA's collective and transactional licensing program. And as such, he has to balance user requirements with the interests of rights holders within the legislative environment. He's a copyright and licensing expert who's been responsible for the development of new collective licenses at the CLA for almost 15 years. Doesn't look old enough, does he? He's head of right holder relations at the UK CMO, which deals with text and image-based works. He's responsible for the strategic management of CLA's relationship with right holders and other stakeholders, and works in partnership with authors and publishers and visual creator organizations to develop the CLA's licensing framework and other services. He also is responsible for the CLA's relationships with other CMOs around the world, collective management organizations. He has held several editorial roles in book publishing and has an MBA from the Henley Business School at the University of Reading. And on his right, we have Martin Senftleben, who will speak to issues that his papers have raised in respect of data licensing. Martin is Professor of Intellectual Property Law and the Director of the Institute for Information Law at the University of Amsterdam. He also works as an off-counsel at Bird & Bird in The Hague, and his activities focus on the reconciliation of private intellectual property rights with the competing public interests of a social, cultural, and economic nature. Open science, digital autonomy of researchers, platinum and digital ecosystem regulation, copyright data improvement, there's always room for that, and content recommender systems. He also works in behavioral advertising, consumer empowerment, and the development of a sustainable intellectual property policy, which is very much what we'll be looking at tonight. We all are working in an international industry, so I think I'd like to start just by looking at some of the developments. Mainly across the pond, funnily enough, because it's very much been in the news lately. President Donald Trump's administration has denied funding to Columbia University over its failure to prevent pro-Palestinian demonstrations. The university made policy changes, we understand, imposing restrictions on demonstrations, introducing new disciplinary procedures, and reviewing its Middle Eastern curriculum. In April, Harvard received a letter from what I believe I'm allowed to say, the Big Orange Baby, announcing the curtailment of federal funding at Harvard. The president, Alan Garber, asserted that the university would not surrender its independence or relinquish its constitutional rights, and have since filed a lawsuit in the Boston Federal Court to try and block the White House from the executive from freezing billions of dollars in federal funding in major research programs. And I understand, was it yesterday, there was an announcement that $450 million of federal funding was apparently being withheld from Harvard. 10 American universities and colleges have formed a Big Ten academic alliance. The presidents of Harvard, Princeton, Brown, and Hawaii and community colleges have collaborated on a letter criticizing policies on the current American administration concerned about the attack on academic freedom. There is a list of the universities within the alliance, including Illinois, Iowa, Michigan, Michigan State, Minnesota, Northwestern, Ohio State, Oregon, Pennsylvania, UCLA, USC, Washington, and the University of Wisconsin-Madison. More than that, we are witnessing a threat to the rule of law. If the link at the top of the page will take you to a film from CBS's 60 Minutes explaining what is happening to some law firms. On the 25th of February, executive orders affecting 6 law firms were issued. Each firm had a connection to an investigation of a legal case related to Trump or his allies, including the Mueller probe of 2017 in respect of alleged Russian interference in the election, subversion of the 2020 election, and Trump's alleged mishandling of classified documents. In March, more executive orders were issued, and they threatened to bar attorneys from where they work, courthouses, and federal agencies, and cancel the contracts of law firm clients. So, for example, an aerospace company could lose its federal contracts if it continued to instruct the firm in question. By memo, the president has directed the Attorney General of the United States to seek sanctions against any lawyer anywhere for unreasonable and vexatious litigation against the government. What unreasonable means is perhaps something you'd have to ask the president. 9 major law firms did deals with the White House. Some say they were pressured, not by a written order, but by, quote, a message from the White House threatening an order. The 9 firms don't admit any wrongdoing, but they have together agreed to give nearly $1 billion in pro bono legal services to causes that the firms and the Trump support. One firm frames its reasoning as, quote, the best path to protect our clients, our people, and our firm. Some lawyers are resigning. They have expressed concerns that there is nothing in the agreements that have been signed between the firms and the White House that prevents the president from issuing a subsequent executive order against the law firm in question, and 4 firms are standing up and fighting in court protected by a restraining order from a judge. On the 1st of May, believe it or not, 1,500 New York attorneys recited their Pledge of Allegiance, chanting in favour of the rule and law and hoisting high pocket constitutions in front of the court. And in 50 other cities, thousands of lawyers performed the same protest. We're going to talk about AI and intellectual property, and I think we have reason to be worried. Jack Dorsey tweets, "Let's get rid of all IP law." Presumably no one had pointed out to him that with no patent law, the entire asset base of the tech companies would also fall over. Zuckerberg, you probably know, has authorized his AI training team with no payment to authors or publishers to download and train on 82 terabytes of pirated books from unlicensed libraries to train AI systems. And Meta has also announced it will be using all public user data, including text, photos, and comments, to train AI from June 26. Despite this practice, it had already been in play at Facebook and Instagram since 2007. Is this fair use? Well, we have got a judge who's weighed in and questioned a fair use defence in Meta litigation. On Thursday, the 8th of May, Carla Hayden, the Librarian of Congress, who was confirmed by the Senate in 2016 for a 10-year term, was dismissed. The following day, a pre-publication report, which is quite unusual coming from the Copyright Office, Copyright and Artificial Intelligence Part 3 about Gen AI training, was issued by the US Copyright Office. And the following day, on a Saturday, the respected Shira Pulmuta, who served as Register of Copyright since 2020, was informed that her employment had been terminated. James.
Hi, I don't know how to follow that really. It's going to be a bit of a change of tone. It's great to be here. I was going to be in the audience, and on Sunday I learned I was going to be doing the seminar. But I mean, I've got some things to say that are very much on topic of the originally described seminar, and I hope you find this an interesting and illuminating presentation. So, first of all, about CLA, the Copyright Licensing Agency. So we are a collective management organisation. We operate voluntary collective licensing schemes in the education and the business and the public sector in the UK. We help our customers legally access, copy and share the published content they use while making sure that copyright owners are paid for the use of their work. We are owned and directed by our member organisations. So we have 4 members, ALCS representing authors, PLS representing publishers, and two organisations, DAX and Pixel, representing visual artists. There are many acronyms in our organisations, and I'm not going to spell them all out. You may be aware of some of these organisations already. We're a not-for-profit company, and over the past 4 decades, we've generated over £1.5 billion in collective licensing revenue that we've distributed to over 200,000 writers, publishers, and visual artists. So this is a diagram showing the kind of the framework of collective licensing in the UK. We just kind of find it easier to put it all on a diagram. So on the left-hand side, you've got the rights holders. So they are writers and journalists, publishers, visual artists, and photographers who have contributed to books, magazines, journals, and the websites that are published by those publishers who mandate PLS. They each assign their rights or mandate or provide the authorization to the 4 members that we are owned and controlled by, ALCS, PLS, Pixel, and DAX. And we bundle up all those rights, CLA, and then we sell blanket licenses in the main that allow the copying, used to be photocopying, doesn't happen that much anymore, scanning, emailing, digital copying in many different ways, including media monitoring, which I'll get to later, by licensees in many different sectors. We sell the licenses, collect up the revenue, collect data on the usage, and then we pay at a title level the money back to each of those organisations to remunerate the rights holders. So what's this all got to do with traceability, registration, all the other things. So we just to start off, rights holders do not need usually to register their publications with CLA to be eligible to receive collective licensing revenue. We cover all books, magazines and journals published in the UK by default. That's a lot of publications. Last time I asked the operations team, there were over 32 million books, records for books in our database, and nearly 2 million records for journals, magazines and websites. Not every single one of those is actually covered, because some of that includes works which the rights holders have excluded, but that's only a few hundred. The vast majority are available to be copied under our licenses. But a work might not be in that database and might still be covered by our blanket licenses, which say you can copy anything published in the UK unless it's excluded. And if during our data collection exercises we find, or we are told about a publication that isn't in our database, we research it and add it using trusted sources of metadata, for example, Nielsen and Ulrichs, I think is the serials database. So in this world, there is no need for authors and visual creators to register their contributions for publications with CLA. So we find the publication that the publisher published through the databases, and we pass on the money to the creator organizations to pass on following their rules. But ALCS members, the authors, the journalists, and in fact the academic writers, many of whom in the room may well be members of ALCS, we do need them to provide their lists of publications to ALCS so that they can claim really for those publications. And this kind of is part of the sort of the theme, I think, of the evening, which is that the way that copyright management is evolving, it's more and more important for rights holders to provide metadata on their works to organizations that can remunerate them. It's just not mandatory, and I don't think it should be, but this is an example. So I'm going to give you two examples of how we use the rights metadata that we hold in that database to make it easier for users of copyright content. So first of all, kind of how we use the big database of rights metadata. So we make available the about 34 million records through a web-based search tool called Check Permissions, and an API which basically does the same thing, but computers can ask it questions rather than humans. And it's on every page of our website, Check Permissions. You can go and look up your own titles if you wish. You can look things up by ISBN, ISSN, or the title of the work. It's pretty good at finding things, but sometimes the thing you mean isn't always at the top. We're not Google, we do our best. So as well as humans who are licensees who check whether a work is covered, we provide an API to third-party technology providers who, on behalf of their customers, check whether a work is covered by the license, what the rights are, whether they can do something under license. It also powers our own DCS platform, Digital Content Store it's called, which is used by over 150 universities in the UK and overseas. So that platform is the platform through which universities in the UK report what is copied under our licenses to make available to students as part of their course readings. It's all the digital course readings that they get through their university platform. All UK universities do use the Check Permissions data in some way, because they're all really copyright compliant. We've got some super keen customers who want to do the right thing. We provide them the technology to allow them to do so. So Check Permissions streamlines the supply of over 200,000 extracts, chapters, articles a year to over 2 million students in the UK. So again, while it doesn't require the rights holder to register, because we've got this database that we built up over the years and we look for anything that isn't there already and add it, we are able to streamline this copyright content use. And it's a demonstration really that entire sectors of the users of content can use the technology that we provide to automate copyright compliance at scale. And I've got another case study too from a different sector. And this is something that is probably it's a niche of a niche, but we license organizations called media monitoring organizations So these are companies like Cision, Meltwater, Onclusive, Signal, who provide a paid-for service where they look for mentions of their clients in the news and the press, and they analyse that. So it's kind of like a paid-for Google News that's far better. And these organisations, as a sector, in the UK at least, and generally in Europe, are copyright compliant. They understand that the lifeblood of their business is copyright content. It's the news. It's the B2B news, the B2C news that they supply to their clients. So we have a long-standing relationship with that sector. We represent over 10,000 websites publishing news and business-to-business content, as well as over 5,000 print magazines and from over 2,000 publishers. So with websites, as a publisher, you do need to register your URL with us, because we can't just say, well, you can copy anything on the web. That isn't going to be ever how it works. But there's a lot of content which is registered. But what I wanted to demonstrate is that these organizations that are monitoring online news sources undertake mass web scraping and TDM. They are copying every day, every news story from all those 10,000 websites into their servers. They're analyzing it. They're looking for keywords. They're sometimes even using what you could call AI tools, maybe not generative AI tools, to look for the sentiment in the news story. So they're saying, okay, is this a positive story about this brand or a negative? And we license all that. And they are prepared to pay, and they do pay, and they have done for 2 decades. In fact, since 2021, our customers have reported over 89 million website extracts being copied and supplied to customers under license. So it's a big scale, kind of big data kind of industry. It is an example of effective and transparent collective licensing of a technology sector which undertakes web scraping at scale. Now, what other technology sector is undertaking web scraping at scale? To date, no AI developers have even contacted us to inquire about a similar license, which is a real shame. We've actually been evolving our TDM and AI licensing over the years. So we've been licensing media monitoring to do TDM, text and data mining, since 2011. We developed a couple of years ago a broader TDM license that anybody in any sector can take. But that was kind of limited and said, look, not generative AI, this is a bit too far. That's available for anyone who needs it today. Earlier this month, we launched the right to copy to make a prompt in our business licenses, adding on something that people do every day, just another digital use. But again, they're not training AI tools. And then recently too, we announced that we are going to be developing a collective license for generative AI training, which we intend to launch by the end of the year. So this is in partnership with our members, and we are, I mean, you can see it got into The Guardian. I was quite impressed. Collective licensing and copyright in The Guardian, that never happens. So what we will do is we're going to provide an opt-in, scalable collective licensing solution that will ensure remuneration for publishers and authors who choose to participate. Particularly the smaller ones who just can't do the direct deals. Building on our expertise and our technology where we're already licensing digital users at scale, as I've just described, to basically allow AI firms, big and small, to have the legal certainty to innovate and train their tools. So I think this is my last slide. I did also want to put in, because it was part of the sort of preamble for the seminar, and I think it would be remiss of me not to mention the UK government consultation on copyright and AI. So first of all, we're a member, as are many of the other creative organisations and rights holder organisations of Coalition, which is Creative Rights and AI Coalition, which has got together to reject the government's proposed exception and call for transparency obligations and enforcement of existing copyright law. We note that there are quite a few mentions of collective management of rights in the consultation document, and I just wanted to pull out a couple of these because I think they're really relevant to what we're discussing today. One is the observation that a collective management organisation may wish to reserve rights in its whole catalogue of works, but may find this difficult to achieve. So I would say, actually, there's evidence that it wouldn't be that difficult. We can already express the rights that we control for our members digitally at scale. There's also the point here that it will be important to have collective licenses to allow access to copyright content for large and small market entrants, and we're developing a license to do that. Really, you know, what the last bit says is that really collective management organizations could reserve the rights of their members. That's possible with the technology we have. But really what I would like to end on, this is my last slide, is that we agree that CMOs can play a role in communicating the right status of the works they control. We're quite fortunate in the text and image-based publications world because we have ISBNs and ISSNs, which alongside URLs are a global standard identifier that we can use to always link to the source of what is a publication and who published it originally, and then we can keep track of who then owns the rights going down the line using that ISSN or ISBN as the key. That's not always possible in every sector, I know that. As I said, we're already developing collective licenses for AI training, and we believe that the burden of complying with copyright law should fall on AI developers under existing law, and rights holders should not be required to register their work in any way to enjoy full copyright protection. And that is it.
Thank you, James. We thought it was important that we started with someone who is working for an organisation that is grappling with what you could call the triumvirate of transparency, identifiability and remuneration, which is what James's organisation does. And the role of CMOs is pretty important to do this with the enormous amount of copyright works. Martin, next, is going to share with some of his interesting, controversial, in fact, I believe I called one of them sexy, didn't I? Ideas he has about how some of these...
I remember that one, that's true.
how some of these problems that we're all facing become dealt with. Over to you, Martin.
Yeah, thank you so much, Amanda. And also James for the first part of the presentations, because, well, James ended by saying, whatever we are doing, it must not lead to a registration obligation in the area of copyright, and that's very much in line with traditional copyright policy. Still, and that's Alina who asked me to do this, I'm asking this question, are we, if you want it or don't want it, aren't we anyway in a situation where we get closer and closer to what I would call de facto copyright registration? The broader societal, technological trend underlying this whole thing is that we live in an age where digitization, datafication, these are mega trends that just involve more and more sectors and subsystems of society, whether we want it or not. And so the illustration, the picture chosen for advertising the event is a bit misleading in that regard, because, I mean, whenever I ask a master's thesis student to really actually go to the library and not just sit there and surf the internet, but really go to the shelf and take a book from the shelf, open that book, paper, open that book and read what is in this paper copy, they look at me like, okay, and from which century are you precisely? Yeah? So, and that's a core insight. If it doesn't exist in data format, then it's not there. We live in a world where if you don't turn it into data, then you basically have a visibility problem, a traceability problem, and that has an enormous impact on copyright licensing and enforcement. And that's very much what James illustrated so nicely by giving basically a success story, if you can believe what he said, about how to actually do this. But there is a broader also regulatory trend in this area, and I would like to illustrate this by looking at two things that have kept us busy in the copyright debate for years and years. One is what to do with these online platforms for sharing user-generated content, so YouTube, Dailymotion, and so on, and how can we make sure that those platforms also pay and also channel part of their revenue back to creative industry, individual authors. And then, of course, the new big debate on generative AI. And then when you look at the regulatory solutions that have been found, you will see exactly this, that we are in an area where licensing and enforcement, whether we like it or not, is hardly conceivable without taking this step to developing not just data on the work, but also metadata attached to this, telling users who is the rights holder, which territory is covered, what is the licensing fee, how to conclude the licensing deal, and so on and so forth. First example, the platforms for user-generated content. So YouTube would be one of the most prominent examples. The regulatory response that we got in EU law is that actually rights holders, in order to set in motion a process of content moderation, content filtering, so making sure that certain protected content does not arrive at the platform, does not appear on the platform, the rights holders have to take steps first. And this is what we have in Article 17 saying OCSSP, so these are the platforms, YouTube for example, is not liable if YouTube demonstrates that they have made, in accordance with high industry standards of professional diligence, best efforts to ensure the unavailability of specific work, so filtering, for which, and now comes the important part for our purposes, for which the rights holders have provided the service providers with the relevant and necessary information. So in order to trigger this enforcement mechanism, this unavailability on the platform, you as a rights holder, you have to send information. And then what is this information? Well, sending this notification or whatever is already information on you as a right holder. I mean, this is very much about making available to the public, communication to the public. So the first statement you make is, I'm the right holder with regard to this protected content. This means you also have to send information on the work. You have to send a catalog of the works that are in your portfolio and that you want to exclude from visibility on the platform unless payment is made. And then, of course, you say something about the territory because you make this statement with regard to a certain legal system. So basically you say, I have the rights with regard to the Netherlands or the UK or whatever. So this is a licensing and enforcement mechanism. And what happens is that we trigger a data flow from the creative industry to the high-tech industry. That's what's behind this thing. And the creative industry has to carry the burden of creating those data. So the data investment is made in the creative industries and the data flow to the high-tech industry. Second example, generative AI. So, well, things are ongoing in the UK. Don't do this opt-out thing, if you ask me. Bad idea, don't do it. But we already have it in the European Union, so there is this opt-out mechanism with regard to text and data mining. Here's the legislation. So the text and data mining exception provided for in paragraph 1 of Article 4 of the Copyright Directive 2019 shall apply on condition that the use of works and other subject matter referred to in that paragraph, and now for our purposes the relevant part, has not been expressly reserved by the right holders in an appropriate manner, such as machine-readable means in the case of content made publicly available online. So the basic idea is the same. The rights holder has to do something, has to send information, in this case the opt-out information. You could think this is fundamentally different from the platform example because it's much simpler. So all that is necessary is a right holder statement saying, I don't want these materials to be reproduced or extracted. So if you can follow one of the early cases, the Kneschke Lion case in Germany, there the judge said it doesn't even matter whether it's in robots text or whatever, if it's just stated on the website, that's enough. So let's take a very easy example. You are a photographer and you have your private website, and on the website in capital letters you say, photos that I have made are not available for TDM training purposes. I prohibit this. Opt-out statement. Well, if you want this to work, you will have to enrich the message. Because your photographs, first of all, the question is, are all your photographs on your website? Because what happens technically is the AI crawler comes, visits your website, finds out, oh, I must not index this website. So the crawler doesn't use the website, but continues somewhere else on the internet. So wherever your photographs are to be found on the internet, the crawler digests all the information. So if you want the opt-out to be effective in the way of really ensuring that your photographs are not becoming part of the training data set, you will have to add information on your work repertoire. What are these works? And that's the point where the metadata issue suddenly becomes relevant, because if you don't do this in a standardized form, which this web crawler can understand, or this AI crawler can understand, then, well, I don't know how you navigate this. And then also with regard to the territory, there might be different rights holders for different territories, and so on and so forth. So it's not that easy. It's not that easy. You haven't done an effective job by just stating on your own personal website that you opt out. There is quite a discussion about it. So here's an example of a collecting society in the Netherlands, Pictorite. I have chosen this one because they are administering the rights of visual artists, so photographers, illustrations, designers, and so on and so forth. And they are advising the artists on exactly these issues. But it is really complicated, and it's also a question who should carry the burden of doing this. If we follow traditional logic in private law, intellectual property law, then the person who wants to enforce rights is the rights holder. So it seems logical that the rights holder provides these metadata, unless you wanted to reverse the burden and wanted to say, okay, the AI company wants to make use. So the AI company, whenever there is an opt-out message, should do the very best they can to find out which photographs belong to this individual artist and use the data resources they have to identify those photographs all over the internet. But this is a question open for discussion. But the central point is, again, if we want this opt-out mechanism to lead to the result that certain photographs are not ending up in the AI dataset, we have to enrich the message. So here's another example where this becomes even clearer. Collective opt-out. So in this example, Pictorite itself, that's the collecting society for visual art in the Netherlands, they declared, like many others also in the music field, a collective opt-out for all their members. So the AI crawler comes, visits this website of Pictorite, finds out, oh, there's an opt-out, so the crawler does not index this website, moves on to other websites, and uses and includes in the database whatever the crawler finds wherever else on the internet. And the websites of the collecting societies are extremely poor on who are the rights holders that have given their rights to the collecting society for administration, and which are the works of these rights holders. So in this case, the metadata flow that is necessary for this to work effectively is an even bigger challenge. So basically, the collecting society would have to create a shadow metadata base where the opt-out statement links to this database, and that database would have all the necessary content identification and rights holder information to make sure that the works of these rights holders are not used for AI training purposes. So that's not even the main topic of my talk today. All I'm saying is, whether we like it or not, what is happening here is a huge data transfer from the creative industry to the high-tech industry. So if you want to help the high-tech industry to become even richer in terms of data, then this is exactly what you have to do. Because the data pooling takes place at the level of online platforms and AI trainers. And that's, I guess, an unintended side effect of the regulatory responses that we had to these challenges. And if you ask me, I don't have an alternative in terms of regulatory models. I mean, if you want licensing and enforcement in the data fight online space, then this is what you will come up with, but it leads to an ever-increasing data hegemony at big tech level. And if this makes you nervous, then you should think about copyright registration. Because copyright registration, in the sense of not the old-fashioned registration in the sense of you have to fill in a form and somebody has to stamp and so on, but what could help here is that you create a parallel data collection point. So the creative industry creates its own infrastructure as a counterweight to this process. So you bundle all notifications, you bundle all opt-outs, and you bring it in the hands of one concrete, one complex data infrastructure that has it all. So you do central data enrichment in the hands of just one big data collector. Practical solution would be you have these notifications in the online platform YouTube space, you have the opt-outs in the Gen AI space. So the data enrichment that I have just explained takes place. These notifications, opt-outs are sent to the platforms and the AI trainers, but in parallel, because the creative industry does this effort anyway, so in parallel they are also sent to a central data repository. And you could call it UK IPO, or you could call it EU IPO. But of course, the traditional registration bodies are, let's say, very solid candidates for doing this job. So what could be the advantage of such a repository? I'm answering this here at EU level, but you can replace EU with UK. So the EU is already taking steps in that space. So we had a tender from the Commission about a central registry of text and data mining opt-outs. So the European Commission is already behind this, at least indirectly. There's another parallel tender about a registry for public domain materials and Creative Commons materials. So there is things going on there. The question then, of course, is what kind of data standard, metadata standard do you actually want? So these are basic types of information. Who are the authors, performers, rights holders? What are the type of rights? But at least for the AI space, you will also need, or you will also want, descriptive data. So what's the title, genre, style, semantics, contents of the work? If it's about photographs, my previous example, the AI system, if you want to make sense of the photograph, has to know, is it a dog or a cat or a cow? What is it? So some descriptive data will be necessary. And this is muddy. I mean, this is a highly complex area, and there is no just one generally agreed data standard. But if you manage to do this job, then there might be quite interesting further developments and advantages. So first of all, I think that could be a counterbalance to the dynamics that we see with data just going to the big tech industry. Another important idea is, couldn't this become open data to create a level playing field? Because once these are open data, whatever newcomer you have in the UK market, EU market, can just jump on the train and use the data that have been collected. And if you do an opt-out, you don't have to do an opt-out all the time. You just have to make sure that it is in this repository. So there can be advantages. Counter-argument is big tech can use these open data sources as well. So, I mean, you help everybody in the sector. So, and then about these data things, metadata are a particularly complex and messy area. So there have been quite a couple of studies demonstrating that data are missing, inaccurate, non-interoperable, even in sectors like the music sector that is known for having a relatively strong data infrastructure. These problems are everyday problems. Opportunities are missed in that way because the visibility, accessibility of content is reduced. For recommender systems, perhaps it's not that the system is not programmed in a balanced way, but perhaps the system just doesn't know how to find your content. licensing opportunities can be missed. AI training, as I've explained, AI output could offer further starting points for revenue streams, but without these data issues being solved, the chances are not very high to get this. As I said, I mean, this problem is well known. There is not a lack of data. So this is a picture of Rotterdam Harbor, and the data is there, but it's in all these different silos, and the silos are not communicating, and the data holders might have a tendency of keeping the data to themselves because data is gatekeeper power. So if you are this small collecting society, why should you give away your data, which makes you perhaps obsolete as a middleman? Studies have already been undertaken years ago. So there at WIPO, there is this study on voluntary copyright registration systems. Stefan Hompel, Saula Massalina did this at the time. At the EU level, it has become a priority under the Finnish presidency. In 2019, there have been documents demonstrating this. We had a really extensive study which in the area of copyright, Alain Strovel, for instance, was involved in. Conclusions here were that raising awareness and integrating initiatives, so bringing together the data resources that we have and achieving standardization and so on, that's something that should be achieved in order to establish a comprehensive infrastructure for copyright data. And this is, I believe, what the EU IPO is doing at the moment. So they are looking at these recommendations, trying to implement this. A big step in the right direction already seems to be connecting the dots or the data points. Another advantage, once you bring in a centralized institution, if it was the UK IPO, the UK IPO could set data standards and could say everybody in the sector has to accept at least our data standard. So if you have one central player, one spider in the web, that can also give this player some power to influence the organization of the data. So that's what I wanted to contribute to our today discussion. Thank you so much. Oh, that's a publication on this, so if you're interested, a couple of more details. Thank you.
Thank you, Martin. I want to open it up to questions. You mentioned the music industry, which is, yes, it has pretty good data, but what's always interested me, you have a code for the song and a code for the recording. Sounds like a good idea. Well, the two codes aren't very good at speaking to each other, but on top of that, as you've had a sort of tradition of acquisition by the majors of smaller companies, they then have individual small companies have developed their own data systems and labeling systems over the years, and they're now folded into a bigger company. And then the collective management organizations for songs say, yes, you have the ISWC, but you'll find out that ASCAP also has a label that's unique to them, and there's a tune code, and there's every society, as they try and come together and clean up their data, are wrestling with bespoke identifiers that they've been using themselves. So if that's the best sector of the creative industries in terms of labeling, we have a massive problem on our hands. The thing I found interesting when we were talking earlier was, for me, it was a revelation that actually the best data at the moment sits with the tech companies, because all the right owners have been feeding them this information over the last 20 years. So I think we ought to, I can see some pretty clever faces in the audience, and I'd love to have some questions. Yes, someone will bring you a microphone. Could you say your name and where you come from? That's not Peru, but you know, the company you work for.
Yes, of course. My name is Estelle Derclay, and I'm professor of intellectual property law at the University of Nottingham. And I have one question from James, if I can give two questions to start, and one for Marty. So for James, you covered so much, and maybe I misunderstood something, but when the CLA or even the ALCS, PRS, etc., are gathering the information, do they actually check that information in the sense that you know who the author is and they have to give the information? As far as I understand, this is correct. But what if, because now we're talking about AI generated outputs, it's an AI-generated outputs, and there is no author behind it, and somebody gives whatever name, right? So that's one of the things. So does that go into the database? Do you have these kind of problems? And the question for Martin, sorry, the flow of data. Yes, it goes to these platforms or the big tech, etc. But isn't it, at least in the EU, I'm not talking about elsewhere, but we still have that right in the UK, isn't that covered by the database sui generis right? So they don't really give away their data. They license it or they retain the right, and they just give them the use of using that data. So there is some sort of power that is remaining with the collecting societies or whoever gives the data to the big tech. So that may be another question to think about. Thank you.
Thanks. It's a really good question that we haven't. I don't recall us having wrestled with yet, which is the likelihood of there being an AI-generated creator at some point, whether it's images that are AI created or the author of a book that was then published is actually AI. It's not something that we've tackled, and I would say one thing is that we pass on the revenue and the data we have on the works to our members, and it's their policies actually. So I couldn't speak for ALCS and say, well, what would they do if somebody said, I actually built this tool that wrote that book, can I have the money? It's a great question, I don't know. But certainly at the moment, you do have to, for a work to be allocated any of the money we collect, it has to be published by a publisher. And generally, publishers are not publishing books written by computers, but they may do in the future, and it's certainly something we need to address. It's a great question.
You're right, but I'm not sure the property perspective is the main concern here. So I think from a sui generis database right perspective, you can say, okay, the rights holder sending this information can have a library of data that enjoys sui generis database protection. But then, fair enough, I mean, the platform AI trainer bringing together all these data resources, organizing it in their own, perhaps very peculiar way, they also get a sui generis database right. So you have the database right on both sides. But I think the property issue is not the central point. The central point is the more data you have, the more insight you have into available contents. And the platforms and AI trainers perhaps also have the main resources for finding out what consumers really like. So they collect consumer data, they collect work-related data, which makes them, I mean, the perfect intermediary for bringing tailor-made content offers to consumers at exactly the moment and the point in time when they like it. So that's the thing. It's not so much the property issues. And even if there's a sui generis database right on the side of the creative industry rights holders, the legislation clearly says you have to send this information, otherwise no content moderation and so on goes on. So, yeah.
Just a quick follow-up. Yeah, but they still retain the right to control that data, even if they give it to, they're obliged to give it to.
So how do you enforce that?
Sorry?
So I don't see how you use the sui generis database right as the sword that helps you taming the platforms and the AI companies. So I mean, perhaps we have to discuss it in more detail, but I don't see the practical, like I don't see how these data collection issues and the big tech becoming the main data repositories, the most powerful data owners, how this goes away by just referring to the sui generis database, right?
I mean, we're having this discussion in the law faculty, but in discussions earlier in the day, it strikes me increasingly, we're actually talking about practical problems. If we get too caught up, this is probably a bit naughty to say in this context, but if you get too caught up in the legal framework that they're dealing with, we run the risk of losing sight of the practical problems we have to solve, data lakes, and a subject close to my heart, actually paying the people who made the work in the first place too, which is kind of important. Yes, hi.
Thank you. I'm Séverine Dusselier. I'm a professor at Sciences Po Law School in Paris. Thank you for fascinating presentation, both of you. I would have plenty of questions. So I would limit myself to two. The first one, and you touched upon it a bit, Martin, but the fact that those data will actually be attached to certain forms of certain digital files or embodiments of a work. But a work is something that is a bit abstract. You know, it's an expression that that can take different forms. So in a way, there will be always some blind spot because those data might not be affixed to all the different copies of the work that exist, particularly for old copyrighted works, you know. And there is another dimension to this that, and I will be speaking about images. The question might be completely different from music, from text, etc. But there have been, so you know, when you look at a data set, for instance, of images, and you see, if you look for, let's say, Picasso, and you look at what is labeled in a data set as a Picasso, actually you will have thousands of images popping up. And not only Picassos, actually. You would have Picasso paintings, but you would have also Picasso mugs, or Picasso on T-shirts, or Picasso on baby thing, or even people, you know, painting like Picasso. So actually the training on Picasso is actually the training on many different things. So even if Picasso heirs decided to opt out, they will opt out only for a small portion of the images, and the data might help to enforce that opt out, but still there are a lot of different material that the system can still train on. It might not be considered by all of us as Picasso, but for the machine, it's still a Picasso. You know, even a child, a 6-year-old child drawing like Picasso will be considered by the machine as Picasso in his label. So how do you deal with that? The second question I have is that your system of data is really, really interesting. The metadata is really interesting, and I want to know whether, and it's also a question to both of you, what impact it could have on the output, you know, on the fact that, because there is this notion of transparency that the AI operator would have at some point to explain how the system works to achieve that result. So, you know, if you have those data that is attached to the material that will be in the data set, could you also integrate in your system a feature that would say that then it could also, maybe, because there has been some experience by engineers saying that an output to some extent can be attributed to, you know, you could realize in the latent space what are the vectors that have been influencing a specific output. So if on those vectors you can also integrate the source material, then can you imagine, and maybe it's science fiction for now, but can you imagine that your data will also be able to provide some reconstruction of the materials that have been weighing, you know, most than others in the generation of some outputs? I don't see if it's clear enough.
I think it is clear. I mean, as to the first question, first of all, I think I indicated this already. I'm not a big fan of the opt-out mechanism. So the problems that you are describing are exactly what you get with an opt-out. So first of all, I wouldn't do the opt-out system. But okay, so if we have to accept that there is an opt-out system in some crazy jurisdictions, then yeah, I mean, with the current metadata infrastructures, watermarking techniques, and so on, there's only so much you can do. So you will never manage to really reach 100% point of works if they are hidden or in variations as you explain it, as long as you don't manage to attach the relevant metadata to each and every variation, which from a human perspective still is Picasso. And then the big question is, who carries the burden for that? I guess sooner or later some court decision will be necessary to say, okay, it's the rights holders who have to do it, or it's the AI trainers. You can also, I mean, following what the first, I mean, it was the first instance decision in Germany, but there the judge already used an argument saying, well, AI company, if you are so clever in so many other respects, then we expect some cleverness also in the area of helping copyright owners to get a fair return on the use and so on. So it's a question how these burdens will be distributed. You could also say if the rights holders have made sure that there are enough specimens of a certain type of work, then at some point the system should become clever enough to identify variations of this also in other areas. But my central point was simply these data flow questions, not so much the practical success of enforcement. And the second point you raised, and I think I had an idea what I wanted to say. What was the second point?
It was about how at some point we might maybe technically speaking, and there are some research in that direction, that you would be able to retrace in a way the way a certain output would use different parts of the data set at least.
That's as far as I know, this is already underway. I don't know, perhaps James, you've heard about it, but there are industry initiatives and also university initiatives, supercomputing labs and so on that try to do exactly this. What I know about the results so far is that you get some probabilities, but not hard evidence in the sense of copyright law. So from a copyright law perspective, the question is how high a probability is necessary to reverse the burden of proof. If we can reverse the burden of proof, then a relatively high probability that your music has been part of the training data set, if the system is able to come up with some AI output really resembling your work, then that could be enough for saying, okay, this is sufficient for what the rights holders can do. Now we reverse the burden of proof, and the AI company has to demonstrate that this result was achieved by the system, even though your works have not been part of the training data set. So I guess that's what the copyright question is. We would have to relax the evidence requirements.
Did you want to add something to that, James?
Yeah, I was just going to say from my perspective, a couple of responses to the really good questions. One is that the point about Picasso and opt-out reminded me of an example that Ed Newton-Rex, who's a great campaigner for the sort of not having an opt-out system in the UK, made, is that as a composer of choral music, how could you opt out somebody recording the thing that you wanted them to record and then performing it? And then stuff gets trained on 15 different choirs performing that piece. I do not know how any metadata solution could solve that problem. And that's like a real world problem. I would also really like us to use the words rights reservation, not opt-out, when it comes to the thing that we're calling opt-out. Because what should be happening is rights holders should be reserving their rights, which should lead to licensing, because surely that was the point of having the scheme that the EU have developed before they even knew that generative AI was a thing. And so, but this comes back to, practical questions about policy and are people getting paid? It's not about a no, it's about, well, how much are you going to pay? And I think any solution of a central registration system should have that kind of policy goal in mind, shouldn't it, really? That was really my perspective. I cannot imagine that a big tech firm outside of the sort of research section or supercomputing labs would think it worthwhile spending the money to develop a system which could identify the inputs being used and the outputs. It may be technically possible. I cannot imagine them actually doing it, because what's in it for them? That's my perspective.
From a very simplistic perspective, the ISO issues the ISBN for books, the ISAN for audiovisual, the ISWC, ISRC. I mean, I know in the audiovisual sector that the BBC and Hollywood and ITV all use different identifiers, and Google's now got a new identifier that they want to use for AI-generated works. But there are 29 countries that have accepted the ISCC last May, which is for identifying, it's open source and it's for digital content, and it works across platforms, and it works for any type of digital media, text, images, audio, video, which kind of starts to satisfy your concern, Séverine, that you have different formats of the initial artistic work. And if an ISCC is attached and it's individual, then you start to address that. But of course, the big problem is everybody has to agree to use them. There was a, yes.
Hi, I'm James Hall. I'm doing the LLM here at UCL. I wanted to touch on the point about getting authors paid, basically, especially in light of something that's come out in the last couple of months in the computer science literature about the idea of machine unlearning, that once you train an AI model on a certain data set, computer scientists are now starting to think, well, you can delete certain infringing works from that data set, but the AI can never actually unlearn what it's learned. The damage is done, basically. So I had a question for both the panelists, kind of in the context of a registered opt-out system or in terms of like a copyright licensing agency. If there is a work that, say, is opted out too slowly or is just one of the works that's missed by the CLA, it's used for training data and no remuneration flows because, yeah, there's no opt-out or rights reservation, sorry. What role does an opt-out register or a CLA have in stopping that from being undermined by the idea of machine learning, that once the damage has been done, it's been done?
I can give a couple of sort of perspectives on that. I mean, one is that what we would be looking at developing is a purely opt-in consent-based system where we may end up having to license only the rights that are opted in that particular moment to an AI firm that wants to pay. And but we would never be able to cover and couldn't police everything they'd ever trained on. That this is, if an AI firm does not believe that they are undertaking acts which are hugely, they've got a huge risk of infringing copyright, then they won't come and pay for us anyway. So I think there's a element of, well, what's the worst, what's the bad thing that's going to happen to the firm if they don't delete or unlearn? But what we want to try and do is provide a solution to the problem that is being articulated, which is, well, there's just too much content. There's just no way we can get a license, therefore we need to change the law. And also to make sure that authors that do want to get paid can get paid something. So.
There's also in America, you have a high level of financial penalty for infringement, which we don't have here. Can I just like a show of hands too? You used, when talking about reservation of rights, who chooses? Is it the right owner or is it the creator? Who thinks it's the right owner? Wow, three people.
To do the opt-out.
If you're to choose whether their works can be trained. If you have an opt-out, who thinks it's the right owner?
It's the right owner.
So that's interesting. See, the 60. Who thinks it should be the actual author or performer of the work or the recorded performance? Yes, I'm with you. Anybody else besides the three of us, four of us?
Sorry, is your question the law as is or the law as it should be?
No, I'm asking for an opinion, as it should be, not
Should
as it
be.
is, as it should be. Okay, so let's start again.
You could have collective management organization. Collective management organizations are also opting out right now.
Yeah,
you know,
so
and they
has.
might have just managing the right. They are not the transferee of the right. So you know, you have three possible
actually, they are
persons
a
who would.
transferee of
Yeah.
part of the right, of the
Yeah.
performing right and the mechanical right in
Yeah.
continental Europe.
And then in a sound recording, you might have the authors, the producers, the performers, the collective management organization. You
Yeah.
might have a lot of the music publisher. You might
Yeah.
have a lot of person actually eligible to opt out or make right reservation.
Can I get back to that question that we had on time, like when it does take back? So as I see it from a purely legal perspective, so if the training has taken place at a time where no opt-out, had no rights reservation had been declared, then at that point in time, the TDM freedom was fully granted. And so the training at that point in time was legitimate. And then out of a perspective also from you can rely on the law as is at that point in time, that was a legitimate act of training. And so the moment the rights reservation is done, it can only be for the future, I would say. And then the question from a technical perspective is for future training, is it necessary that you start from scratch? And if you don't have to start from scratch, It's the question whether the earlier data set that you had compiled based on statutory use permissions at the time, is this becoming fruit of the poisonous tree because of the opt-out that has been declared in the meantime? So highly complex questions. So I guess after the rights reservation, it would be reasonable to assume whatever has been used as a resource before the rights reservation becomes illegitimate material, which means you really have to start the training from scratch, which, to bring in another topic, from a sustainability perspective, is bad policy. Because we have all seen the news on these data centers and so on. So it's also, I think, a moment in time where copyright policy in this area suddenly can have quite some impact on how we deal with resources on the planet, also with this supercomputing power to trace back from output what the most likely probable input has been. This seems to require lots and lots of computing power. So if this is done constantly all the time, you will need even more data centers. And yeah, so there are implications there that seem to be quite important.
Yes.
I'm Julian from Bortstein Legal Group. I had a couple of questions for Martin about his proposal. So the first one is the idea that once the copyright is registered, that big tech cannot then engage in TDM with that material without a license? That was the first question. And the second was, as I understand it, under the EU AI Act, they are requiring GPAI, so the likes of OpenAI, to start creating lists of the works. So aren't we already pushing the burden in that direction? Is your contention that that is just practically not going to be workable?
I'm not sure I said lots of things about the areas you are now touching upon. So the first point is clear. If the rights reservation is done, then using the resources for AI training becomes an unlawful act. So that's clear. So it's basically a no. And as James has explained, the no doesn't mean that there's a money flow. The no is just a no. So as a next step, you would need the AI company to knock on your door and say, we have seen your opt-out. How much money do you want to have for using these resources? And the second question is how much reliance you place on that system, whether you think that is an effective way of regulating this. So in the European Union, the answer has been yes, and I think it will keep us busy for years to find out what the practical potential of that solution actually is.
Yes.
Yeah, so I was,
sorry.
if I might just, the only thing I can think of on the enforcement and knowing how the EU enforces other regulations, it would be literally have to be through auditing, going in and forcing developers at their computer. Yeah.
Yeah, but I mean, so first of all, it's too early to say something definite about the granularity of the lists, because there's a working group. You would have to ask Alexander Peukert, for instance, where they stand and what they do and what they are planning. The other thing is the legislation, if I understood it correctly, says that it should have a level of detail that enables rights holders to find out whether their works have been used for training. So some level of really practical information should be in those lists. And yeah, then we will see how the sector reacts to this. We have trade secret protection as well, so there has to come a balance there. And then the question is how to enforce it. So if you train outside of the EU, then the training quite clearly is not copyright infringement in the EU. But if you haven't reported this correctly on the list, then this might be some type of administrative, unlawful, whatever, and the AI office can enforce that. But that would be enforcement according to public administrative law types of standards. And for civil law, the question is whether you have some tort law mechanism that says this administrative mechanism is a protection reflex that also is something that private parties can invoke in private litigation. But that, from my perspective, would not be a copyright question if the training has not taken place in the EU. That would be a question of penalties under, fees under administrative law. And the fines and so on, like in the Digital Services Act, the Commission can impose fines, or the AI office can impose fines for non-compliance with these obligations. So,
Yes. Oh, no, in front here, yes. I'll come back to you in a moment.
Sorry. Hi, I'm Daniel Enti. I'm an IP lawyer at Bird & Bird. I'm going to ask a question, not necessarily about the training of AI models, but I guess the output as a result of the training. I hope it's not too off topic. I've written it down as well. But I was asking if minimal input can qualify a human as the author of an AI-generated work, are we lowering the threshold of originality? And does that risk undermining copyright integrity? So I'm going to throw that out and see where it lands.
Ooh, good one.
James, you want to?
The buckers are whizzing back and forth.
Well, I mean, if I'll go to law school a few years, come back and answer the question, but I don't think I'm quite qualified to do that. So I'm going to hand that back over to you.
Well, I haven't heard the question yet posed in that way. What I'm aware of is that there's a discussion whether the emerging Gen AI possibilities implies that the originality threshold should become higher. Because what everybody can achieve based on Gen AI without human creativity is already at such a level of sophistication that the times where even the smallest the amount of creative choices already helps you acquiring copyright would be sufficient. But to the question as you have posed, I'm not so sure. I don't know.
Philip Johnson, Professor at Cardiff University. It's a similar question to other people have asked, but if you have a situation where person A has opted out and then person B quotes from person A's work and hasn't opted out, while the individual quote might not be an infringement if it's used by training, if the aggregation of quotes, because there's also persons C, D, E, and F, have also quoted from the same piece of work, say article, they're looking far too academic, but would that aggregation mean that it becomes an infringement? Or can you just look at the fact that the person B, C, D, and E didn't opt out, so they're relying on training on that work, despite the fact person A, whose work has now been taken by a substantial part, hasn't in fact opted out? You could do it with photographs or anything else.
I can answer that one. I would say we have to keep the things and the policy objectives underlying the provisions of copyright law separate. So the right of quotation is for entering into a dialogue with pre-existing work and so on and so forth. So that's what the limitation, the copyright exception is about. Gen AI systems don't do this. So the TDM question is just on getting the resources necessary for training. So in the first place, I have doubts that if a rights reservation has taken place, the AI trainer would be a party that legitimately can invoke another person's right of quotation. So a different point of view would be to say the moment the rights reservation has taken place, the AI trainer should make sure that not just the original work, but also those quotations are not indexed in the first place, which makes it similar to Professor Dussolier's point on variations of Picasso's work that might be on T-shirt, on a coffee cup, whatever. So I would place it in that category.
By opting out, taking out the quote, will change the other person's work. So the fact, sorry.
No,
if you take
it's about the indexing. The
quote,
other person's work stays on the internet, but it's not used for AI training.
But if work B is used for training, but you train it without the work of work A, you're changing the nature of work B, which means you're actually affecting how it's being trained.
Yeah, but the TDM process or the AI training process, if I understood it correctly, is the most radical change of the nature of the work that you can imagine, because the system pulls it apart and it just becomes data points and vectors and so on.
It weighs it all. It weighs all the things.
So to the AI system, it doesn't matter whether the quote is in it or not. So if you have a newspaper article with 10 quotes and the system has to filter out those quotes before using the rest of the text for training, for the AI system, I think that doesn't matter that much.
James, you have a
I was just going to say, without sounding flippant, maybe it's all completely pointless because the training is happening in the US where there's a different law there. I'm wondering, in the EU where there has been a regime with Article 4 in it for several years now, is there evidence that it has encouraged AI innovation? Is there evidence that rights holders who have reserved their rights have then gone on to license AI firms? All these things have to happen before we start worrying about whether quotations are really covered by the thing, because really, it's like there's got to be an element of rough justice in the mass training of millions of words of works, whether it's done in the way that rights holders would like or not. There's going to be some kind of rough justice, and that's probably part of the rough justice is if you get quoted, you have to deal with it, I think.
Because of the economic cost of actually
doing anything about
slicing and dicing, so it's all absolutely perfect. I mean,
yeah.
Anyone else? Yes, down the front.
Thank you. I've got some comments to make actually, because I'm not from a legal background, and I'm from a tech background, so you might find them useful. But before I begin to talk, is there anybody else here from a tech background or a tech startup? So half? Almost startup? You're starting a startup. I think that's part of the problem, right? That there are enough tech people involved in this. And so the comment that I wanted to make was, actually, Martin, my company Tickbox has built a system similar to what you've described. Essentially, we allow content creators to create a license. We take key metadata from that license about how they wish the asset to be used. We insert that metadata into the particular asset. The asset can go live anywhere on the web. If it's scraped, and so I think machine-to-machine communication, I think scrapers and bots are going to be, they're already all over the internet. We're going to see an increase of those sorts of technologies. So we're going to see, there's going to be a demand for machine-to-machine communication. What that means that software is going to talk to the software. So you need the labels. You need the labels on everything, because then the bots will be able to filter out things that they're not meant to be using. So if you put an opt-out label on your asset, it will say, well, I don't have permission to use this. So yes, that's what we've done with Tickbox. And I suppose a comment that I wanted to make was about labeling and metadata. So there are standards that are being adopted. There's ongoing work with C2PA. Has anybody heard of that? Okay, a couple of people. C2PA was founded by the BBC, Adobe, New York Times, so really big media organizations. It was designed to help label provenance of generative content, but actually the programmatic language that it's been developed in can be extended to include copyright information and opt-out. And so we're actually extending it on our side to include licensing information. So C2PA is a really good place to start. They are looking to, and it's open source, they are looking to integrate as many other standards. So some of the terms that we're really interested in is in copyright. What does this term actually mean, right? So we need that, the schema to be standard. So C2PA is looking at standards and pulling in the standards. So I think if there's going to be one standard above all other standards, because it's pulling in all the other standards, it's probably going to be C2PA. I think we can be we're quite excited about it, so we're doing a lot of work with C2PA.
Okay. Is it? Oh, is the other tech person out the back would like to say something too? Good.
Piggybacking on that question, I guess, is how do we determine sort of whether it's opt-out or opt-in, or it's a tag, at what point does the description become a copy? Because this is copyright, so it's an expression, not a concept, not an idea. And so in order so how do we achieve the right balance? And I guess this is where the standards come in. How do we achieve the right balance of having a description that is detailed enough that the work can be identified as a copyrightable protected work versus making an outright copy of that work? And the problem with those standards as well is we live in a global world. Copyright law isn't global. And so where do we put how do we achieve a standard that protects those works, whether opt-in or opt-out, using a description that is to an extent where we can identify a copyrightable work because the description is detailed enough, but we don't copy the work entirely. That seems like a very big challenge to achieve. And I'm wondering, you know, as well, who decides that? Because, you know, at the moment, the justice system decides whether or not a work, ultimately, when there's a dispute, whether a work is copyrighted. So does it go back to the courts? Because legislation hasn't given a very precise description of what is and isn't a copyrighted work. It's still subjective in a way and goes back to the courts. So I feel like there might be an issue as well in the actors of who makes that decision on those standards.
Can you hear? Could you hear?
Yeah, it was
okay,
perfect.
Off you go.
I'm not sure I really share this concern. I mean, first of all, if it's really descriptive metadata we are speaking about, very often they will be in a different format anyway. So if you add the information then that the photograph you have on the internet is a dog or a cat, then the word dog or cat is very different from the visual information. The same with the musical piece where you say, okay, this is country music, this is from the 90s, something like this. So, and then many of these metadata I think would not really be eligible for copyright protection because they are functional. So it's not like you exercising lots of free creative choices, but you want to convey the most accurate, most helpful information on this masterpiece of literature, art, and so on. So I would have doubts that many of these metadata would be eligible for copyright protection, even though the threshold for obtaining protection is relatively low. Where we get closer to your problem scenario is perhaps in the field where it's you try to add metadata to something that is already in text form. But even there, I mean, unless the metadata would reproduce certain very specific, very original types of expressing a meaning, or something, I'm not so sure I would be too concerned about the metadata becoming copyrightable material.
Can I just add something?
Could you wait for the mic?
Yeah, sure. Although I'm a pretty loud person, so so the way that the C2PA is being developed, and excuse me if you already know this, they are looking at standardized terms already. And I've got a background in photography, so for photojournalists, for example, there are standard texts that they use to describe who's the owner, who's it been assigned to, you know, who kind of created the piece of work. And so coming to who decides what these standards are. So I attend a lot of these WIPO conferences, so World Intellectual Property Organization, and they're getting more and more interesting because the last one was actually about infrastructure for this sort of metadata stuff. I can see that a lot of people are working with C2PA from that conference. I could also see that other EU governments, like the Finnish government, are doing a very interesting project looking at standardizing licensing terms. So that's the thing, I think. And also the ISCC code that you mentioned earlier, C2PA have done an inclusion of that already. So once somebody works on a body of standardization, I think C2PA is just bringing it in. So it's looking good so far.
Now, isn't that nice to hear something optimistic instead of the pearl clutching that the copyright industry seem to be indulging in? Any more questions? Over here.
Sorry, this comes back to the kind of registrability point, which is my biggest concern about it is kind of up-and-coming artists, whether they be kind of... Prime example, my friend's a graphic artist and she consistently has her work stolen by US companies and reproduced on mugs and t-shirts and sold. And she's consistently filing DMCAs and I am concerned that if you have a registrability system, it's going to become, what if there's no checks and balances of the legitimacy of those claims, then she might be in a situation where those US companies are then kind of registering it straight away and she's like second to register, but she's the actual author.
Is she putting things on Facebook?
Yeah.
Well, this is an obsession of mine. Facebook strips out the metadata on any image you load onto your page for a start. So,
but it's tricky then when that's
Yes.
that's where we're going in terms of advertising, and that's how she started her business, and that's my concern, is the kind of up and coming ones that aren't going to be aware that they've got to do this registration system, and then they just get undermined by other people because they're not quick enough.
This is also a concern for independent songwriters or small recording artists who don't necessarily have a Universal or a Warner Brothers to enter into licensing agreements, who very much feel left out. And you, Martin, certainly were talking about the quality of culture if everything's not in there. You know, that was a sort of Roman law perspective as opposed to a common law perspective.
Yeah, well, I mean, with regard to that point, it's perhaps also a question how literal we want to take the term registration. So, at least to my knowledge, we don't have, I think, a big discussion on really having a traditional registration system in the sense of, if you want to obtain protection, you first have to fill in the form, pay the fee in many different countries, in many different currencies and languages. And so, I mean, we don't speak about this as a patent law type or trademark type of registration system. So it's more about tapping into these data flows that are taking place anyway.
I get that, but then you might be in a situation where you've got this confliction.
Yeah, I mean, one thing of solving it at that level is that at the moment where conflicting information arrives at this central repository, the repository has basically two options: recording both and leaving them as conflicting claims, or using the conflicting information coming in as an instance where the system says, okay, then this is removed, and the two parties sending the information are contacted and consulted, like make a statement within a week or something explaining why you think that you have the claim concerning this work. And perhaps it can be resolved by one party saying, I have the rights for the UK, and the other party saying, I have the rights for the Netherlands, and then that's fine. Or there is really a pirate who perhaps would not respond to such a request for information. That's what we know from customs border enforcement, that most of the time you have these really pirated counterfeit shipments and so on, then there's just no reaction to whatever enforcement measure is taken. So, I mean, that's what I can imagine as practical solutions.
And collective management organizations already use this when there's a conflict, that it sort of kind of comes out of the pot and it's resolved before it actually can go back into kind of generating revenue, or certainly having revenue attributed to it. Are we cooked? Well, look, thank you all for coming. It's a very vexed question indeed, and I'm really glad we had at least two technologists in the room, because in fact some of this, and a professor from California was saying this afternoon, quite a lot of the problem is getting the copyright industries and the tech sector to talk to each other. Otherwise, can't ever actually get out of the weeds. Do you want to say anything, Elena? No? And thank you for Martin and James, and I believe the bar is open.